Okay, Google, what is a regulatory sandbox?
A regulatory sandbox is a new regulatory approach that allows live, time-restricted testing of innovations under a regulator's oversight.
In other words, it gives businesses a space to play with new ideas and products within certain boundaries before they bring them to market. Since the United Kingdom's inaugural launch of a regulatory sandbox back in 2015, the concept has gained traction on a global scale. Arizona recently adopted a statewide version of their own. Several other states and even the federal government seem likely to follow their lead. But questions abound. What exactly is a regulatory sandbox? Who decides how it is run? And perhaps most importantly, what are the pros and cons of implementing a regulatory sandbox?
So say there's a mortgage lender that has a whole new algorithm and they say we can get more people into houses living the American dream and kind of solve the housing inequity gap. And they make dozens of loans that turn into hundreds of loans that turn into thousands of loans, even if it's just limited to one state. That's all well and good until the possibility that algorithm was wrong. So then you have a potential ripple effect of foreclosures. Now you have the company that says, oh, we made a mistake, and it's because of the sandbox that would shield any type of remediation for the consumers or any type of liability for the company that made that mistake, whereas outside of the sandbox, those loans would not have been made.
Driving the debate about whether or not to make use of regulatory sandboxes is a disagreement about the very idea's definition, not to mention worth. Many innovative products are required to undergo strict regulatory scrutiny before being brought to market, and some never make it. A regulatory sandbox is touted as a reprieve from regulation and a catalyst for innovation, but its value is contested.
In its simplest terms, a regulatory sandbox is really a safe space by which companies, startups, mature growth firms to financial services incumbents are able to test their innovative product or service in a limited setting.
So I think regulatory sandboxes are critical at this point because I think we're kind of in an international race right now. Our company is going to go abroad and only do business in certain areas where their regulatory structure is allowing that to flourish, or is the U.S. going to be part of the discussion?
Part of the trouble with defining a regulatory sandbox is that it can mean so many different things and that it has different iterations across the world, on the state level, on the federal level. They're so new that it's hard to make any conclusions of the end products of a sandbox and how they can contribute to the greater economy.
In the UK in 2015, that was the only country that had a regulatory sandbox. 2 years later, 17 countries had them. Today, we have more than 50 countries that are looking at implementing or have already implemented a regulatory sandbox.
It's pivotal that the U.S. presents a kind of innovative front, or else we're not going to be writing the rules of the road.
If it's justifying market participants getting around reasonable consumer oversight protections, then that's not only problematic, but it sets a stage for a dangerous narrative that somehow civil rights, consumer protection laws, and oversight are in the way of true financial innovation to solve market inequities. And that's one of the biggest concerns we have in defining a sandbox in a broad term.
Due to the intangible nature of regulatory sandboxes, experts are divided about how they should be implemented, who should oversee them, and even whether they should exist in the first place. As a relatively new idea, the available data on these sandboxes are limited and open to interpretation. Because of the lack of consensus, measuring the overall impact of launching a regulatory sandbox at any level is challenging.
I think the first question that regulators really need to ask before they go into sandboxes is, do we even need a sandbox, right? And then the second question is, why do we need a sandbox, right? What are we trying to solve for?
We would be proponents of handling at the federal level. We're not in a state or local-based economy. We're in a very international, integrated, global economy. We should be thinking about, how can the UK and the US work together to bring products to market?
laws like anti-discrimination laws like the Equal Credit Opportunity Act, the Community Reinvestment Act, all passed in the Civil Rights era. They were in direct response to market failures, which is a euphemism for discrimination and racism in the market both. So when we talk about these laws in the context of a regulatory sandbox, it's especially problematic when they're reframed as obstacles to progress.
And we need to make sure that we're keeping up with the different innovations and the different tools that are at our disposal.
One of the things that is a significant problem for me on the regulatory sandbox front is that, there's a recent UN report that came out on regulatory sandboxes, among other issues related to fintech. And what they found was that of the sandboxes that they did a deeper dive analysis on, nearly a quarter of them did not conduct a feasibility test on whether or not they should have a sandbox and whether or not this is the right environment for a sandbox, right? That to me shows there's a lot of competition in this space. There's a lot of, hey, let's just put out a press release and saying we have a sandbox without actually understanding, do we really need a sandbox, and then the actual requirements that go into a sandbox.
I think that there's a lot of different sides to the debate. I think that there's a lot of concern, that a sandbox means that companies can run amok and just kind of ignore certain laws. That is definitely not the case, and that's never what we've been advocating for. So, a regulator is not just going to, let a company kind of run amok. They're going to have solid guardrails, and there's always enforcement opportunities, and there's private rights of action. I mean, the U.S. is a very, very robust regulatory environment.
You get the engagement, right? And you get the one-on-one, oftentimes, communication. You get the oversight from a regulator, and you get the understanding of what regulatory regimes within that country apply to your product and service. It gives kind of real-time data and insights to a regulatory authority that may never have been able to access such information.
We're waiting for the CFPB to come out with their idea of what a sandbox would be, but regardless, I think it is definitely something that has the strong protections, both investor and consumer protections in place, and then guardrails around it to ensure that there isn't any harm happening to the different populations.
Success metrics that we've been seeing in the regulatory sandbox space, time to entry in the market, right? That's a big one. Through traditional process can take months, if not years, to enter a market. And the second thing that we've seen in terms of successes is, have you been able to raise capital, right? And what we've seen from this is that a number of companies have raised capital during the testing period.
The idea that kind of the up and running sandboxes on the global scale are somehow models that we can readily take on to solve implementation issues has a lot of problems. It really is an apples to oranges comparison. The structure of the U.S. regulatory system is vastly different from the UK or Singapore. So to use those sandboxes as a model that can just be taken off the shelf and implemented is a bit idealistic.
Back in the 90s when the internet was created, we took kind of a wait and see approach, and that's why it is what it is today. And so I think that if we quash this innovation in the banking space before we understand where it's going to go, or in the blockchain space where there's tons of different uses from food supply to agriculture, to food safety, I think that, we're doing ourselves a disservice, both from an American competitive standpoint and from, being able to see what these innovations are actually going to come to.
There might need to be some reform, or there might need to be some strengthening, but we have the tools to do this in a transparent and equitable and multi-stakeholder way.
The interplay between innovation and consumer protection has always been rocky, yet both continue to be crucial focuses for regulators. While some are convinced of the benefits, others remain concerned and ask, what is the real cost of a regulatory sandbox?
You have a structure in place, and I think before we can just summarily dismiss it and say, no, actually what we need is a sandbox, there's a really big assumption there that I think has gone unquestioned in the broader narrative. And I don't think there's been enough of a robust discussion in that space to really kind of double down and say, we need the sandbox to be competitive, and we need the sandbox to solve our financial inclusion issue. We need the sandbox to drive or increase the number of banked individuals. So I think the jury's still out on that premise.
I think that it's going to be better for consumers if we all work together on this, and that, first and foremost, consumer protection, and then also working with the companies to see, what are some innovations that are going to make consumers' lives better, possibly make them more financially literate, save more, have better disclosures. A lot of companies are thinking of innovative ways that may not fit within the legal construct currently that is going to actually be better for consumers.
Sandboxes are just one tool in the regulatory toolkit. There's all sorts of other tools, guidance, waivers, no action letters. Now we've seen the creation of innovation offices. Testing and pilots was just a bit different from the actual sandbox itself. So that question of do we need a sandbox, I think regulators need to kind of go back to the drawing board and say, well, here's what we have, here's what we're missing, and does a sandbox kind of fit to address those challenges of ours?
So innovation in the financial service marketplace is not only unavoidable, we're already in the middle of it. But when it comes to financial innovation, nobody's out there saying we need to turn the clock back and go back to writing checks, sending things through the mail, sending faxes to your broker to make a stock purchase. The real question is how is that innovation interacting with current civil rights and consumer protection laws, and what are the structures that allow that interaction to really produce effective and strong consumer protection regulation, but also encourage innovation and the kind of market evolution.
The conversation between regulators and the regulated is already occurring, and I've been very excited to see that. So a couple years ago, working on this, there was just huge question marks, and there were just buzzwords being thrown around. Now I think that companies are feeling comfortable enough to go into the regulator.
We're still early on in the sandbox process or sandbox regimes that are being implemented around the world, right? I mean, it's still to be determined whether these sandboxes ultimately offer some really interesting success stories. So again, we're still very early on at this stage.
It should be an ongoing dialogue between the two, and if we figure out that an issue or an idea is not viable, then that's one thing. But then working with a regulator, you kind of find the best regulatory tool to get where you want to go that can, better serve consumers.